people don't have to go through lengthy proceedings, it would be a good thing. Thank you.
Mr. James To. Madam Deputy. In this apology bill, I am one of the members who was rather more vocal regarding the statement of facts. Madam Deputy, I fully appreciate that the introduction of the apology bill is intended to foster reconciliation and to remove the unnecessary resentment. But I think we have to tread carefully. We thought we are moving in the right direction, but I think we have to be comprehensive in our thinking. First of all, why people are reluctant to make an apology, including the government. That's because they are worried about legal liability arising from an apology. There are some classic examples, like a disaster or a serious blunder. Let me cite an example. Let's not talk about the administration for the time being. Over the past couple of days in Hong Kong, a few days ago, in fact, there was a serious industrial accident with a casualty of 3. The contractors, Kamsing and CLP, said that they did what they should, and they have provided all the security or safety measures. But the family members said that they would never forgive the company. They may have put in place all these safety measures. I mean, they're talking about safety measures being put in place. I think this is rubbing salt to the wound. I would not say that they dare not offer an apology because of the absence of an apology bill. Whether someone would apologize may not be due to their worry about legal liability. They refuse to apologize maybe because they have provided all these safety measures. In some cases, the safety measures may be 20% short of what is required, and that may be the cause of the accident. Until they've got to the bottom of the matter, the contractor might feel that on the face of it, they've provided the safety measures up to 80–90%. Or they may feel that they have done 100% regarding safety measures, and they're refusing to offer an apology. Is it because they know that they were in the wrong, or is it because they know that there are some facts about inadequacy and they're worried about legal liabilities, and therefore they are not offering an apology? I think there is a subtle balance to be struck there. Let's take a medical blunder, for instance. Obviously, does the doctor know how much he is in the wrong? And if he makes an apology and admits to the wrongdoing, then that may mitigate the whole thing. There must be some examples like this. in our apology bill, now for the excluded facts, except for the excluded facts, you can imagine that many people who are in grief will feel comforted if the other party were to offer an apology. And there may be excessive apology that would numb the victim's family members, and they would stop seeking justice. There may be a lot of cases like this. In particular, there may be very experienced people. We have to bear in mind that an apology may not be coming from the person who committed the wrongdoing. Like a doctor, for instance, the apology may not come from the doctor himself. It may be coming from the hospital executive. I would not go so far as to say that they are trying to be excessive in their apology, but they are very experienced in dealing with these kind of incidents. If they know that, as a matter of principle, if they make an apology and disclose certain facts that they may not be getting fully to grips with, if these apologies can make the victims' families feel better, then these people, that there will be a lot of people who are experienced in handling these kind of situations who would take advantage of this opportunity. I'm not suggesting for 1 minute that these are bad guys. I'm not suggesting that they are trying to mislead the other party. I'm not suggesting that they are trying to take away the idea of taking any further action on the part of the victims' families. But if there is no balance there, at the end of the day, when the family members sober up, or when the family members have gone past the stage where they need comfort, we've dealt with many cases like this. There are different stages of emotions experienced by the family members. When they calm down, they may not necessarily want to seek compensation, but truth. Because of this bill, many family members may, as a result of the apology, refrain from seeking the truth or any compensation. Then what will be the consequences? That the SJ would like to see resentment dissolve, and they don't really want to have any ill feelings. And the family members may put things behind them and get on with their life. And there may be areas that they can get to the bottom of, but they take the apology as the truth. And they choose not to pursue the matter, that's something for them. But we have dealt with enough complaints like these. At the second stage, let's say 6 months later, 9 months later, they've gone past the worst emotional turmoil, and at the very beginning, they may be crying their eyes out, but after 6, 9 months, they have put that behind them, and they would very much like to get to the bottom of the accident. And this, in a way, would be a lesson for the officials. And this is driving society forward, and this can be an encouragement, or this can be a push for society and officials to do a better job. Now, with this bill being enacted, there may be serious cases. There can be a whole gamut of cases. To put it bluntly, sometimes the administration would set up certain committees, or LegCo may carry out the investigation. But for, let's say, medical blunder, let's say someone is suffering from liver infection, and by administering the steroid, you have to administer the prophylaxis to prevent any problems caused to the liver problem. And maybe the family members accepted the apology and don't pursue the matter, and the whole thing has come off the boil and it's not in the news anymore. And the whole thing would just die out. And the hospital would not be under any pressure. Now there are all these alerts, like there will be a pop-up on the screen for the doctors to prescribe the prophylaxis and so on. And because of this acceptance of an apology, that it may seem as if we have successfully conciliated the matter. We have resolved the disputes, and the family members do not harbor any grudges against the hospital, and the doctor doesn't feel any guilty conscience anymore. That's all for the good. But thereafter, because of this acceptance of an apology, we may lose 4 to 5 lives. As a result, we could have taken the opportunity to push for changes for the better. In many cases, it's not the civil proceedings, it's the discovery of the facts that would cause concern among the public. It would cause concerns on the part of the hospital. And the whole thing is not settled just by the acceptance of compensation. And the hospital may set up a committee to investigate, and they may ask for more documents from the administration. They may call a press conference, and the Secretary for Health, Food and Health may, at the end of the day, instructed the hospitals to be careful in the administration of drugs. Now, with the apology being accepted, we may have suppressed the actions that could have been taken. Through these cases, we could have driven the revamp in certain areas. The Lemma tragedy is a case in point, in my opinion.
So Michael Tin, Dr. Yu Chong Yim. Thank you, President. First of all, I have to declare my membership of the Bills Committee. Many members have spoken on Clause 8, Bracket 2, but there is no evidence to show that after the enactment of the Apology Bill, how court proceedings or the claims of damages may be affected. If we have the Apology Bill enacted, are we going to have more court proceedings or litigations, or are we going to see a reduction of them? There's no logical deduction that you can make, because there are two opposing forces. Because when you make an apology, you may contain a statement of fact which may show that you admit that it is evidence of your admission of fault. And then the other party thinks that there's a higher chance of winning a case against you. And that's an incentive to initiate court proceedings. But look at it from another angle is also valid. Sometimes because of the anger and the frustration, what the party needs is an apology. And when one is offered, he's pacified and he feels that justice has been done. He may decide not to pursue the case anymore, or the case should not be brought to the court. So both arguments may stand. So this is a question of how we can verify the effect of the law. It cannot be done by simple logical deductions. Some members are very concerned about the inclusion of this clause, bracket 2, to the effect that the decision maker enjoys a discretion. That may lead to the derogation of the policy legislative intent of the apology law. And therefore, some would even suggest that Clause 8.2 should be deleted, and they have made reference to laws in other jurisdictions, and they don't have something like Clause 8 bracket 2. But we cannot say under any logical deduction that the discretion in Clause 8.2 would have an impact one way or the other on litigations. Although we don't have, in Hong Kong, we don't have this apology ordinance yet, and we cannot really verify anything. In the US, 3 scholars have conducted a comprehensive study. Benjamin Michaels, Lawrence Van Horn, Kip Wiscusi, published in 2016 an article entitled "Sorry is Never Enough: The Effect of State Apology Law on Medical Malpractice and Liability Risk." And it simply states that apology is not enough, and they try to take a look at the state apology law and the liability risks brought by such laws. The 3 authors collected information from 2004 2011, altogether 3,517 litigations in the U.S., in 35 states of the U.S. And they look at what happened before, the litigations before and after the enactment of the apology law. And they try to find out whether with the apology law enacted, were there more or fewer litigations to claim damages. The apology law in the U.S. Does not contain the discretion in our clause bracket 2. Let's look at the conclusion. Apparently, an apology law is very attractive, but there's nothing empirical to support it.
Relatively appealing, but empirically unfounded.
More detailed conclusions are, this is my translations, are like this. And the apology law cannot achieve the intended objective. This law cannot reduce litigation or court proceedings. The study shows that in respect of the chances of litigations against doctors, there's no statistical implications.
Are not consistent with the intended effect of apology laws, as these laws do not generally reduce either the total number of claims or the number of claims that result in a lawsuit. Apology laws have no statistical significant effect on the probability that surgeons experience either a non-suit claim or a lawsuit. 嗱，咁佢個研究咧喺3517宗嘅訴訟裏邊。
In respect of the 3,517 litigations, only 2% of the doctors face charges of wrongdoing. For these cases, 2.6% of them, 65.4% ultimately went to the court for a decision. And among them, 51.4% resulted in damages paid. And in respect of another 44.6%, where the court was not involved and the litigations were settled, of these 34.6%, 7.1% ultimately involved the payment of damages.
嗱，三位學者其實
The three scholars offer some explanation on the findings. I think their explanations can provide some insight on whether we should have bracket 2 in our law. Let's look at how they explain their findings in the U.S. cases. They think an apology will provide some information to the family which they would otherwise not able to know. There would be some statement of facts, and they would convey the impression that someone did something wrong. So although in the U.S. their laws do not have something like our clause 8 bracket 2, the patient or the family of the patient will be given an incentive to act on the new information provided in the making of the apology and to try to find evidence that can be adduced in court. So even though they don't have something like clause 8.2, according to the three scholars, offering and an apology is not helpful in reducing litigations. The patient or the family members would get to know some factual information in the course of the apology. And they will be given an incentive to find more evidence for the decision maker. So in Hong Kong's case, even if we were to cancel or repeal Pt2, it will not help us achieve the legislative intent of having an apology law, i.e. In reducing litigations and court proceedings. At the Bills Committee, I said a number of times that some wording in the bill should be amended. Instead of having regard to all the relevant circumstances, it should be just and equitable to do so, only if it's just and equitable to do so. I thank the government officials for listening to us. The amendment to be moved would bring about a very important balance, and that is Clause 8.2 can only be invoked under special circumstances. And we want to prevent a situation whereby justice cannot be done or public interest is not protected. Well, the apology law seeks to separate liability and apology, but we cannot allow apology to override to override justice. So for 8.2 is a balance. So under normal circumstances, apology and liability would not be regarded as the same thing. But in special circumstances, the decision maker may, having regard to the circumstances, and if he is satisfied that it's just to do so, he can admit the information or fact mentioned in the apology in the decision making. There's a question of mismatch with the Chinese and English version of Clause 8(2). In English, it's just and equitable. And the Chinese version is 屬公平之舉, is just and fair to do so.
提到喺8(2) 嘅條文嘅時候咧，可以再
Maybe when we proceed to the discussion of Clause 2, we can have a more detailed discussion. For this part, I want to let you know that in a recent study in the US by scholars, there's no scientific evidence to prove that it's effective in reducing litigations, and even though in the US they have nothing like our Clause 8.2, an apology law is not effective in reducing the court proceedings or litigations, although it also doesn't increase litigations. And although the apology law wants to separate liability and apology, but we must make sure that public interest, justice should not be compromised. Therefore, I support the government's proposed amendment to Clause 2. So I submit.
Ms. Alice Mack. There are lots of people A lot of people, it is difficult to make an apology. So sometimes it's very difficult to get a sincere apology. But when it comes, especially when it comes to professionals, let's say, for example, an engineer or any professional, it will be difficult for them to make an apology because insurance may forbid them to do so. Once they make an apology, they will not be covered by insurance. Should there be an unfortunate incident, even when professionals would like to apologize, they would not be able to do so. And it is because there is no apology ordinance in Hong Kong. Apology makers are not protected. As a result, the matter will have to go through a long process before it is resolved. I have dealt with a lot of medical blunders. The complainants would like to get not an astronomical amount of compensation or disqualification of the doctors, but the truth and a sincere apology. The word "I'm sorry" is something that families would like to hear from doctors. So I support the apology bill. I heard from Mr. James To that with an apology ordinance, if families are happy with an apology, so they do not continue to pursue against wrongdoings, it might affect claims or improvements in the healthcare system. But if you heard Dr. Edward Yiu, you might realize that Mr. To worried too much, because with an apology ordinance, it doesn't mean that people, after hearing an apology, would not pursue. Family members understand that an apology would make them feel better, but it won't stop them from pursuing the case or taking any other follow-up actions. In US, UK, Canada, and Australia, there are apology ordinances to clarify liabilities and responsibilities. And overseas experience tells us that sometimes when an apology is proffered, the dispute might be resolved earlier. Today we're here to scrutinize the apology bill. Of course, we would like to achieve the same goal. And it states under the bill that an apology is not an admission of fault or liability. And when it comes to determination of fault, legal liability, or resolution of disputes, an apology offered should not be taken into account. As a result, people who would like to make an apology would not worry that it will be used against them. It is a kind of safeguard or protection to the apology maker. As I have mentioned, I have dealt with a lot of medical blunders. When I make arrangements for doctors to meet family members, the doctor said to family members, yes, we have missed something. But it's only after your son has passed away that we have missed a blood test report. And family might say, well, then apologize. But the doctor would not apologize. The doctor would only explain what has or has not been done. So if there is a law to protect apology makers, so they can apologize to family members at a time when they are suffering, they would feel some kind of solace. Well, this bill protects apology makers, but there is one point of contention, is Clause 8, Bracket 2. A lot of members have mentioned have mentioned about this. It says that where there is no evidence available for determining an issue, the decision maker may exercise discretion to omit a statement of fact, obtaining an apology as evidence in the proceedings. This indeed is controversial. The original intent of the bill is to protect an apology maker so that what is said will not be used as evidence. However, under this provision, it says that an apology may be used as evidence in the proceedings. Well, you may need to think that if there is no evidence available and the decision maker can exercise discretion to omit a statement of fact, it will enable a check and balance. I believe that courts will be able to make a fair ruling. It applies to civil proceedings and disciplinary proceedings, say, for example, that of the medical council. In the past, in a lot of instances, even though the government has done something wrong, they refuse to apologize. With the apology bill, the government would be bold enough to apologize. Some people might criticize that, well, in that case, people always ask for an apology. We hope that this bill will enable those aggrieved to find some comfort when they hear the words, "I am sorry." So the FTU will support the bill. I so submit.
Does any other member wish to speak? Ms. Claudia Mo. President, the apology bill is a rather controversial bill, and I think it's better to have the apology bill than not to have the apology bill. The journalists would from time to time be sued for defamation and also for inaccurate reporting. There may be mistakes made. Should one offer an apology would make the situation better slightly. But there are many journalist friends of me who would say that you're not supposed to make an apology too easily, because if you make such an apology, then there may be claims for compensation. There is no need to prove wrongdoing or because of your apology. And this is an admission of fault. Now, with the apology bill, does it mean that there will be no liability? If you say that once an apology is made, then everybody will be happy, a shake of hands, a pat on the shoulder, then everything will be hunky-dory. And it doesn't matter if one commits a wrongdoing, as long as you say, "Sorry, sir," it would be okay. So there's the conflicting thing lies. So to what extent would the liability be there? This bill is a very thin copy. I am a member of the Bills Committee myself. The bill may contain a couple of pages, but we were really troubled by it. If you do not read the bill in sufficient detail, then, like Ms. Alice Mack said, the content of the apology can be used by the judge. We can feel relaxed if it is the judge. Here, the bill says the decision maker doesn't necessarily have to be a judge. The decision maker includes the court and that the decision maker refers to someone who collects and judge the evidence is not necessarily an arbitrator or any other body or individual having the authority to hear, receive, and examine evidence in the proceedings. Now, we got bogged down on this for a long time. Now, if there is a block of flats and the owners' corporation's chairman can be the decision maker, the government said that normally for an owners' corporation they have a legal advisor, and I do have some doubts in this regard still. I think the government didn't do it meticulously enough. We asked whether this apology bill is applicable to legal proceedings. We enjoy here in this council the protection under the Powers and Privileges Ordinance. Would the bill be applicable to legal? The answer is no. It seems that when councillors make speeches, they are protected by the Legal Powers and Privileges Ordinance, and they enjoy this superior position. If you apply the apology bill to the Legislative Council, then they lose the protection under the Powers and Privileges Ordinance. And the administration submitted a CSA to say that this doesn't apply to LegCo. Maybe I didn't hear members sufficiently clearly, and some said that this bill does not apply to the council for the time being. By implication, it can be extended to LegCo in the days to come. The government doesn't even have to study this. This bill must not be made applicable to the Legislative Council, whether it be the panel's House Committee or the full Council or any other subcommittees. If you were to say that the apology bill applies not so much to the full Council but the panels and other committees, then it's not a good idea, because people would leave their remarks here at the Council. So I support the administration's CSA in this regard. There is also the other point that the apology bill is intended to minimize the litigations that are troubling both parties. In the Western world, there is an abuse of litigation. People are very litigious. If you buy a cup of coffee in a coffee shop and you scold your thigh because of your carelessness, still you can sue the coffee shop, and you can say that the coffee is so hot, so excessively hot that a spill of the coffee is scalded the drinker, and he can ask for compensation. I think it's a matter of anger on the part of the customer, and the coffee shop is willing to offer an apology, or they may bring down the temperature, and it may leave the coffee for a while before serving this to the customer. In Hong Kong, we're not just concerned about the journalists being sued by the government. Even the chief executive sent solicitor's letter to the newsroom. With this apology bill, can we offer an apology? still, they said that there can be arbitration, and they use broad terms. Of course, in law, you can't make it too rigid. You can't really get down to the minute detail. Now here they talk about in the public interest, in the interest of public justice. Now this is beyond dispute. Public interest, I may consider something of public interest, and the President might say that this is neither urgent nor significant, and so it's open to interpretation what public interest really is, and it is open to interpretation. At the end of the day, I still have some nagging doubts about the role of the arbitrator. And not so much arbitrator. It is the decision maker. It is very clear in English. Decision maker is the person who takes the final decision. It is he's the decision maker of a body. But I still have some doubts. Now you may say that why do I support this? Notwithstanding the doubts. In terms of legalese, I think they have tried their best. Of course, there can be amendments going forward. 2 years down the line, you will revisit the implementation of the bill. I still have some doubts here. Please do not have any misunderstanding. This apology bill doesn't apply to criminal proceedings. If someone beat up somebody else, and then you say sorry, and you'll be getting away with it, still you can be prosecuted. Criminal proceedings, criminal matters will not enjoy any protection under this apology bill. But I remember at the Bills Committee, the last question that I put was in para 6. This doesn't cover criminal proceedings or the proceedings in the schedule. I turn quickly to the schedule. Regarding the proceedings, you have the proceedings that are not applicable. You have the CAP 86 COI ordinance, commissions of inquiry, and also the control of obscene and indecent articles ordinance, and the coroner's ordinance proceedings, and so on. You make it very specific that proceedings under these 3 ordinances will not be applicable. Have you missed out on anything? The administration admitted that they're not being exhaustive. There may be some statutory bodies that are not fully covered, and they can make further additions in future. I would have thought that they should cover all the bodies, and there is no rush to get this bill through, and there is no urgent case that require immediate settlement. I've got some notes here. The Civil Aviation Department might have something in the law that this bill is not applicable to. I remember the Civil Aviation Department, something about the inquiry, 448B about the CAD. Well, it doesn't matter at the present moment. I don't feel that anybody in Hong Kong is abusing the judicial process. I don't think we need the apology bill to keep down the number of litigation. Now, I feel that it is the government that is abusing the judicial process, the disqualification proceedings. If they feel that a certain member is not taking an oath properly with this apology bill, can they make an apology? It doesn't apply to the council here. Can they walk out of the chamber? Can they offer an apology in front of the microphones and they make an apology and everything would be okay? But that's not really the case. They would cherry pick. They cherry pick the legislation as they see fit. Thank you.
Hi.
Mr. Michael Tian, Mr. Leung Kok-hong, I don't think the numbers of members present is in compliance with Article 74 of the Basic Law.
田北辰議員。
Mr. Michael Tin. President, on apology, I think I have some experience. When I was chairman of KCR, there were many controversial issues, and I had to consider what to say to the people of Hong Kong and the press. When there's a major incident, I would, on behalf of the KCR, I would say sorry for causing inconvenience. I was stopped by some colleagues. He advised me against making an apology, because the more you say, the chances are KCRC may be sued. I joined the subcommittee on the bill, and I realized the motive of the colleague. This is the status quo. Apology is unprotected. Saying sorry because of this and that, because I have done something wrong, that can be turned into evidence. You may get yourself into trouble. I don't want to maintain the status quo. I want more people to be willing to offer an apology. So I cannot agree with scenario 1. I'm in favor of having an apology law in Hong Kong. If we all agree that we should have a piece of legislation on apology, so you may ask, why there are so many arguments and disagreement in the Bills Committee today. Well, the DSE results are announced. The candidates are most worried if they have to reach a consensus in the discussions part of the exam, because if someone does in the group doesn't cooperate, they may get a very low mark. They may even fail. As a group, we spend a lot of time to discuss clause 8 bracket 2, and that is scenarios 3, 4, 5 on this board. What is clause 8.2 about? Under normal circumstances, if you say sorry, if you offer an apology together with the explanation that follow the apology, which is called a statement of fact. That sounds very professional and formal, but under special circumstances, if the statement of fact is the evidence for the decision maker to adjudicate a case, the decision maker may omit the apology, the statement in the apology as evidence. So there are two levels of discussion in respect of 8 bracket 2, whether we should allow the discretion. That's one level. Many members said that the intention of having the apology bill is to encourage people to make apology. And if you have 8 bracket 2, people are afraid of the discretionary power, and they may have misgivings, and they would refrain from making the apology. So we don't want to have something cosmetic only, and the legislative intent cannot be achieved. Well, I'm not in favor of removing this discretionary power, and that is I want scenario 6. It's unconstitutional. If the statement of fact in an apology is the only evidence in a court, in a litigation, then apart from protecting the one who has made the apology, we must also make sure that the complainant, the other party, has the right to justice. Otherwise, we will be doing too much. I think the Secretary for Justice understands my point. When the majority of us agree that we should allow the discretionary power in clause 8 bracket 2. Then the second level of discussion is about how wide the discretion should be. In the first draft, the government talks about that if the decision making is satisfied, it is just and equitable to do so, having regard to all the relevant circumstances. It can be done. And now it's also in 2 more limbs are added in the public interest and in fairness, and also all other circumstances. So after a round of debate on semantics, legal issues, and the government would narrow down the limb, and that is it is just and equitable to do, having regard to the justice and public interest. And we then accepted this final formulation. In this case, the interaction between the pro-establishment camp, the pan-democrats, and the government was very good. The government was willing to listen to our views. I hope that this will be the case for other discussions, and the government will be ready to adjust its position in view of feedback from us. How should clause A bracket 2 be worded? I don't think many people can differentiate scenario 3 or 4. I can't. It may be very similar to scenario 2. Under scenario 2, a statement of fact will not be protected. They can just say sorry. They can't add anything to that. And under scenarios 3, 4, and 5, many people are worried that they don't want to take the risk. And and people would just say what I said, sorry for the inconvenience. And what happened, when asked what happened, you have to keep your silence. And is it very useful just to say you are sorry? Apart from expressing regret and shouldering responsibility, and you are taking care of people's emotion. When I came out to apologize, people are sort of pacified, because after an incident, the chairman was willing to come out to apologize, although I didn't bow to down 90 degrees. And people start felt that they are cared, and an instant apology can resolve many the conflicts and disagreement. If you step on the foot of another passenger and you say that you're sorry immediately, the anger would sort of reduce. A bad apology is no apology, according to some people. And if only an apology is offered and nothing else, it would be a big advancement in our community culture. I would say an apology is better than nothing. If we want to heal the community, if we want to reduce the rift between people, this is the way to go for it. And Hong Kong would be the first jurisdiction to have a piece of legislation on apology. It would be very helpful in reducing the social tension and creating an amicable atmosphere. But the government should work harder on this, because you have a number of factors in that limb. I'm speaking to the best of my ability to help you. For the rest, you have to pick up the task. I support the bill and the CSAs. So I submit.
想發言。
Does any other member wish to speak? Mr. Leung Kwok Kong, I still think that the number of people present is not in line with Article 70 of the Basic Law.
會議現在暫停，明。
Meetings adjourned to be continued at 9 o'clock tomorrow.